Welcome to Self-Represented in Family Court. Your host, Tracey Bee. That's me. So, here we discuss strategies. Yes, strategies and how to use them to get the results you want in family court. If you're self-represented, pro se, pro per, or if you have an attorney and you just need to know what it takes to get through this complex family court system we have, this is the place to be. We discuss strategy. We discuss tactics. We discuss tips and tricks. We discuss techniques. We discuss secrets. We discuss it all. Whatever it takes to get you the strategy that you need, that's it. That's here. That's what we do. So sit back, take notes, and kick ass. Well, hello there. It's me, Tracey Bee, and you're listening to Self-Represented in Family Court. I'm back for another episode. And today I wanted to extend a little bit on the topic that I talked about the last time. The last time I made a distinction of the people who are pro se, whether they were pro se by force, which is when they have little options but to represent themselves, and pro se by choice, which is I like to call the self-represent. And I made a distinction for several reasons, but if you want to know, go back and listen to last time's on the topic. This week, I wanted to talk about legal costs in family court. And the reason I decided to talk about that now is because that's one of the main reasons why people are pro se by force. And some may start out as pro se by force and wind up choosing or opting to remain pro se even when they do get the resources to hire an attorney. But attorney's fees are not the only fees that come up when it comes to your family law or family court case. And as many of you know, there's some jurisdictions that require you to pay for things just like simply filing a petition or motion in family court. I remember the day when that was considered unconstitutional. But things have changed. Things have changed. So anyway, let's talk about those fees or those legal costs that are associated with either starting or defending a case in family court. And when I say family court, I'm only talking about divorce and or custody and maybe even child support. But I don't talk about abuse, neglect cases or anything other than the three that I just mentioned for various reasons. And I mentioned that because the costs associated with handling or being enmeshed or involved in an abuse or neglect case can be way more than what it costs to have a divorce or custody case pending. So let's start off with the basics. You're at the decision stage of, your custody or your divorce case, and you want to keep costs down. Well, what cost usually comes up? Well, at the decision stage, you're usually in the position where you're gathering information, you're assessing your situation and your circumstances, you're trying to figure out what resources or what methods or processes you can use along the way once you get started. So all those things, there may be some expenses that come up. Expenses to do background searches or to do any sort of tracking or any sort of investigations, whether it be private investigations, skip tracing, whatever it is. Or you may need to, something as basic as getting copies. Sometimes those copies can run you into the hundreds, if not thousands sometimes, just to get copies of documents that you might need for court. Using apps and software, there are fees associated with those as well. And so you want to get an idea of what those fees are like, especially at the decision stage, because that's the best time, because you need to understand that there are going to be fees that come up. There are going to be costs that come up that are unavoidable. Some, there are hacks, there are shortcuts, there are ways to get around things, but you still would like to know what those things, those items that might come up that will cost you. So you're at the decision stage, and you decided that you need to, accumulate or acquire information. You need to do a little bit of an investigation. You need to make copies. You need to download apps and use apps, incorporate apps for whatever it is, documenting, witnessing, whatever it is. Okay. So you're there. You've decided to do that. And so you're past that. Now you decided to file. You're going to file. You decided, yes, this is the time to file. Now, this may be the time that you might want to give a consultation or two, which might be a good idea. No, it is a good idea. I always recommend, whether you decide to be pro se or not, to at least speak to two attorneys to get their idea or their take on your situation. And I say two because the thing about law is there is no right or wrong or black and white. There is none of that. There's always a matter of perspective, a matter of positioning, a matter of, which side of the table you're standing on. So you want to get at least two so that you can get sort of different perspectives. And that way you can make much better decisions. You can make much more strategic moves now and down the line. So don't do free, guys. Please don't do free consultations. Free consultations are really just a magnet to get you drawn in. Free consultations, they don't really do much more than what you can find by doing a Google search. Free consultations are just usually general information. Attorneys who give free consultations don't really ask to see copies of your legal documents, or they don't really look up your case and see what happened in the past. They don't really take the time to do that. It's free. They're not going to do all of that. You might find a unicorn that might go above and beyond and do some or all of those things. But free usually means that they're just regurgitating anything that you can find on their website or any other lawyer's website. So please, if you're going to do free, still go ahead and pay for at least two reputable attorneys in your area who has some sort of familiarity with your particular court and or judges and possibly the other attorneys in your area. So that's another cost. And how do you get around those costs? Well, you can sometimes negotiate with those attorneys. When I was in private practice, I would actually do a sliding scale for some people. It depends on the referral source. That means it depends on where they came from. Of course, the bar association is a good source because a lot of them do sliding scale fees, even for consultations. I think when I was in private practice, when I was listed on the New York State Bar Association's website or list, I think the consultations were like $45 an hour. And then, I was affiliated with quite a few nonprofits. So if the nonprofit sent them my way, I would give them an abated or reduced price for consultation. So it depends. But do your due diligence and find out if you can find someone who offers some sort of reduced rate or discounted rate or something to give you actual paid consultations. So, but again, try to get at least two paid consultations from reputable attorneys in your area. Okay, so this is the time you decided to file. And so filing, again, will probably accompany some sort of legal fees or legal costs or court costs in addition to attorney's fees. So you're going to have filing fees, and you're going to have, again, you might have copying fees, additional copying fees. You'll have process server fees. You'll have those fees. Now, in your jurisdiction, they may have what's called a waiver, a fee waiver program or fee waiver assistance program, where the court will actually assess your financial or your income situation and determine if you should have your fees, your court filing fees waived. Usually the programs or the states that do have these programs, they usually only cover the filing fees. I don't think, I've done a little research, and I don't think I've found anyone who's done more than waive the initial filing fee. Any other fees that come along with your case are usually not included with. So filing fees meaning the fee to file your petition or your motion or your complaint or whatever it is that you need to file to get your case. And usually they, every time you file, I believe, every time you file a new case or a new case is started, I believe you have to apply all over again. Again, it depends on where you are. So definitely explore that. That's always an option. Um, Other fees that come up with the filing is, like I said, process server. You have to pay a process server to serve the other party. And depending on where they're located, the fee for that can be any upward of $200 or $300. Of course, it's going to depend on where the other party is located, where you're located, the number of attempts they need to make, et cetera, et cetera. But that's usually a fee that's nothing that can be waived because it's something that that's usually required unless you're in a jurisdiction where service can be done by another means, where, because in-person service is what I mean by service of process, when the other party has to be served in person. That means you have to hire someone or pay someone to hand deliver the complaint or the petition or the motion or whatever it is to that person in person. If there's other means of serving them, like, it depends on what the status is of your case or where you are. You may be able to serve them by email. You may be able to serve them by their prior attorney, which usually keeps the fees that way. Sometimes even just by mail, certified mail. It depends. So, it can be anywhere between $5 and $500. But that is a fee that you need to anticipate having to pay. There are jurisdictions that still have sheriffs or constables or whatever they call it in your area, find out who do that for you. And they are government employee, which means that they usually take a much less expensive, cheaper fee than an independent process server. So explore that option. I mean, sometimes you get what you pay for. They're not all equal. They're not all the same. They're not all as diligent as independent, and then vice versa too. So again, that's your part of your project. You need to make sure you explore all of that. The sooner you do that, the better. The sooner you start to calculate all the expenses, because there's nothing worse than getting your case started and it has to be dismissed for lack of prosecution or stalled unnecessarily, and you have an imperative issue that you need the court to address because you couldn't come up with a fee to have the other person filed, or you couldn't figure out how to locate them, which is you can do a background investigation to locate them, which again might incur a fee, and then to have them served in person. So please do that stuff up front. Do that as soon and as early in the case as you possibly can. So now you've done that and you have a court date. Your case is already filed, it's completed, it's accepted. And now the next step is it's going to go to either mediation or the court's calendar. The court meaning you're going to go for first a conference, preliminary conference, or whatever it's called in your jurisdiction. What fees can be associated there? Well, some court require parents to pay what's called, or it could be called, a parent education fee or something like that. I know New Jersey has a fee like that. I believe there's some other states that have fees where you have to either take a parenting education course before the judge even sees your case or before the case even makes it to mediation, or some places you have a fee to pay for that so that down the line, either you'll be required to pay something, do something like that, or it covers some other services that's provided by your court. But that's usually an additional fee that might be required at the time of filing, or it might be required sometime thereafter, anywhere between the two, if that's what your court requires. Then we get to mediation. Some courts have mandatory mediation, and if that's the case, you have to pay for that. Some courts have their own roster of mediators, which means that the attorneys or the professionals who are on the roster have to qualify to be placed on that roster. And that's the list that you'll get when you are at that stage in your case. You'll get that list of those qualified mediators to work with. Usually they charge a fee that is much less than an independent mediator, because some people opt for mediation, even where it's not required. Some people for mediation. And even where it's required, in some places, you can still have an independent mediator. Either way, you're going to pay. And those court rostered mediators usually charge an abated fee or a reduced payment amount than an independent mediator. And they're usually just as good as independent mediators. I mean, there's some other issues that you have that you might have with working with a mediator who's on the court's roster. But from, this episode is just strictly talking about the fees. And so sometimes you may get into a court required mediation program and deal with one of the roster mediators. And they usually charge anywhere between $50 an hour upward to $150 or $200. I don't know, because I haven't looked at all the rosters for all counties in every 50 state, but I do know that most places, they are less expensive than working with an independent mediator. And then some places have independent mediators on their rosters. Either way, there's a fee involved. There are places, the workaround, there are places that will allow you to do mediation, and you don't have to use a court-appointed or court-rostered mediator. You can go to a nonprofit. I know New York has different programs or different organizations that do mediation, and they do it for free for the first hour maybe, or sometimes the first 2 hours, and then you pay after that. So explore that. Always look for ways to get around paying these additional fees, because honestly, I really believe that if you only have a limited amount of resources, a limited amount of funds, you want to use those when it really is absolutely critical to your case to use them. And working with a mediator may not be that place to use all your resources. For some people, it might be, but for some, it may not be, especially where it's court required and you're dealing with a very high conflict other party. So mediation is probably not going to work. You don't want to expend thousands of dollars on mediation when, you have a feeling it's not going to work. That's the hardest thing to do. Sometimes you don't know, but, you have an idea. And mediation is still useful even in that situation. It's just that I don't think you should be spending all your resources on that when you have a huge, huge probability or likelihood that the other party is not going to, work with you reasonably during mediation. Okay. So you've gotten past mediation and you're on your way to your first court appearance. What do you need for mediation? You really need to just bring your documents. You don't really need an attorney, so you don't need to spend money on hiring an attorney to go with you to mediation. You need your documents. You need your list of what you want, the list of what, you're iffy on, and a list that's an absolute, I don't care. And then you need, your evidence, your proofs, so you've gotten your copies, you've spent money on copies, on obtaining copies, on, using the softwares to organize your things, and you're going to mediation. So after mediation, what costs might come up between the time you've mediated your last mediation, not just one mediation, your last mediation, and you're ready to go to court? Mediation didn't work, and you're going to court. If it did work, then the only expenses you might come up with at this point would be additional filing fees. If it didn't work, then now, again, you want to revisit whether or not you want to get consultations to help you figure out what's going to happen in court now that you're going to court, and you're definitely going to court, especially if you didn't get consultations prior. If you did consultations prior, you may not need to actually get additional ones. But if you are that kind of person that need that additional reassurance or assurance that going to court for your first appearance may not render in anything outstanding, then you may decide that you might want to just go ahead and, forego spending more money to an attorney. Again, so your first appearance, you're going to court. Usually what happens in your first appearance is the judge wants to make sure that you guys attempted to resolve things, whether you can resolve anything, what the status is of anything that's been an issue before, if you've been to court prior, if this is just a modification or enforced a subsequent petition. And you usually want to uh, issue temporary orders, or you should ask for temporary. You don't really need to spend any more money to prepare for your first court. So you had your first court appearance. The judge decides that whatever it is that you're asking for, not something to decide on, or the other party, they're not going to decide on, but they are going to end temporary. What does that mean for you? Well, if it's a temporary order not in your favor, then you may decide that you might want to start working on additional information, gathering additional information, additional documents, quote unquote evidence to help you prepare for your next court appearance to substantiate why the temporary order should not be stand in place, should not be temporary. It should be changed. And what does that mean? That might mean you may want to work with, you may want to hire a private investigator, not to bring up in court, but to help you get more vital information that you might need for court. I don't recommend people, especially pro se, going to court, letting the court know that they hired a private investigator especially when they're pro se. I do not recommend that. I think that is catastrophic for people to do. Unless you know what you're doing, I am not a fan of people who do that, especially pro se. But you can use one to help you gather things and that you can use to bring in court, but you don't have to reveal how you got it. As long as you're doing it within the rules of the procedural rules of evidence, which every single court has. So you may want to do that. You may want to, decide now is the time. You didn't think that there was anything really at risk until you went to court and you saw the judge and see what the judge's position is or the judge's take is on the issues in your case. And now you think there's a real threat. And so now you realize that you need to take the time and effort to actually work on gathering whatever it is you need to gather, acquiring information and supporting document, proof, evidence to help you bolster or present your case in a much more advantageous way. So private investigators cost anywhere between $100 an hour. What you could use them for? It's 2025. There's an app for everything. There's a way to find almost anything on anybody these days without really employing the use of a private investigator. Sorry, you're private investigators. I'm not trying to take any money out of your pocket, but honestly, there's so many different ways that I've found people, information, data without paying for these services, the services of a private investigator. And you can too. And if you don't know how, sign up to work with me for a month and we'll get to the bottom of it. We'll figure out a way to get exactly what you need at a reduced cost and without expending so much money just trying to acquire the documentation that you need. So it's at the court and you don't like the temporary order that the judge has said, or you don't like, the way you see the judge is leaning. So you decide, yes, I'm going to take my case seriously and I'm going to start actually presenting it or packaging it the best way I can right before it gets too late. And so, yes, you've decided to, now you're using software, you're using apps, there may be fees to acquire things from government agencies or bureaucratic agencies. You may have to pay for that. Like I said, private investigators, you're using all that. Those are fees. When I say getting things from bureaucratic agencies, you might want to make FOIA requests. And you can do a FOIA request at any time, actually. You might want to do a FOIA request, and I believe FOIA requests are free. I think you have to pay for them. And those fees vary depending on where you are. But a FOIA request is a Freedom of Information Act request, where you're requesting information under the Information Act, under the First Amendment, which the umbrella is the First Amendment, from a government agency or entity. And you usually do that by writing, or you do it on their website if they have that access, and you have to pay for that. So things like that, you might have to pay. You might have to pay for medical records or therapy records. You might have to pay the institution to actually provide you a copy of those. You have to pay, like I said, clerical administrative fees, copying fees to get copies of reports and records and things like that. So if you didn't before, or you did and you think you needed those things, but now you do, those might be additional costs that come up at this point. So now you have gone to court. You're actually on your way. You're in the thick of things now, and your case has been going on for months. What other fees might come up? Well, you might decide you want to work with somebody like me. You may want to work with a strategist to help you, again, position your case in a much more advantageous way. Someone who can help you see whatever you have, whatever your situation is, whatever your circumstances, whatever fine part, not just yours, but the other party, just for the overall case. You may need someone to give you purpose that you can't get on your own because you don't have that much experience. You don't really know the judge. You don't really understand the process. You don't really know the lawyer. It could be a myriad of things. Family court is multi-layered, multifaceted, and multi-directional. So there's so much going on. You may want to work with someone. You may still want to be pro se. You may want to remain lawyer represented. Either way, you may want someone to work with you to help you. You may want to work with someone who specializes in narcissistic abuse. You may want to work with someone who specializes in parental alienation. You may want to work with someone who specializes in DV. You may want to work with them on a limited basis. You may want to work with in an advisory role. That might be an expense that comes up when you're in the thick of things, when your case is not tolerable. I don't know if that's a word. And you see that your case is going to require a little bit more attention, a little bit more effort on your part. And so you may have to put a little bit more money into it. And that's fine. I will take this minute down to caution. When you're working with coaches, be very, very careful in their qualifications. I cannot tell you the number of people I'm coming across who are calling themselves strategists or coaches and experts, and the only experience they have, family law or family court, is their own case. And don't get me wrong, I think that there's some people, divorce coaches, the ones, especially the certified ones who was taking certain programs, I find them to be a little bit more credible because they're trained in not necessarily the strategic, but emotional and the practical when you need that and afford to pay. But the ones who are calling themselves custody coaches and pro se coaches and legal coaches, and the only background they have is their own case, I wouldn't necessarily trust that the information they're giving you is going to really help you. And no shade to anybody who gets those, who hires those people, work with those people. No shade to the people who actually get people to hire them. But I'm just cautioning you because I see that often. And I've actually had several of my audience members come to me within the last couple of years telling me how they were ripped off by some of these people, some of these same people. And so when I have the chance, I caution people. I have my favorite. Some people, some coaches who I will refer, or who I will co-sign for, who I will support. But there's a ton more that I just won't. And I have 3 in mind of the whole mention. So, but anyway, so you may decide you want to work with, a coach or a strategist. You may decide you want to get an expert involved. There are DV experts, there are behavioral experts, there are autism experts, There are vocational experts, or, you name it. There's an expert or an advisor or a consultant or, a myriad, a host of people who can help you understand the nuanced issue in your case so that you can present or you can better present those issues in court. They can be very expensive. They can run you into the top. But again, that's one area where I would recommend to some people that they have limited resources. Because if your issues are very nuanced, or you have a judge who's anti whatever your issue is, and you think you want to get them to understand or to see where you're coming from, it's a new issue for a judge because the judge is new or the judge is new to that specific area of law. You may want to spend money on an expert. Again, it doesn't have to be the top qualified expert in the country. I see people falling for that. They will go and, beg, borrow, and steal to come up with $15,000 to pay an expert that they could have simply hired a counselor or an advisor or a consultant and spent a fraction of that money. That's your job. That's your job to use your critical thinking skills to decide, to determine it. Again, if you don't know how to do that, there are people like myself who will help you. Making decisions or analyzing things, information, data, whatever, is a problem for you or is not your strong suit or is a weakness for you, but it's something that you realize, you identified, you need to give some time, money, and attention, feel free to ask me, and we can do it. We don't have to do it in a month. We can do it in a 1-hour session. We can come up with other alternatives in a 1-hour session. I've done it. I do it all the time. So again, you're in the thick of things in your case. You may want to work on yourself. You may want to get things done to yourself. You may want to go to school and get a vocational training certificate or degree. You may want to get a bigger apartment because that's an issue for the court. You may want to some sort of mental health or physical health attention or treatment that's going to cost you because, you can't afford to pay for your insurance. You may want to get insurance now because that's an issue. You know what I'm saying? So when you're in the thick of things and you see that the court is actually making an issue out of things that are your vulnerable spots or your vulnerable points or your weaknesses, you may want to spend money. You should want to spend money on those things. That's one area, again, that you should not want to ignore because you just don't have it. I get it. Some people just don't have it no matter what. But I also think that a lot of people who don't have it, it's not that they don't have it because they just don't have it. They don't have it because their priorities are all screwed up. They're confused or they're oblivious to what they should be allocating their resources, or how they should be prioritizing their money. Again, I'm not trying to offend anyone, but I've been doing this for almost 21 years now. And I've learned that a lot of people in front of the court make bad decisions. They make bad moves based on acting out of desperation, out of fear, out of anger, out of spite. And then, it comes back to haunt. A lot of times it comes bite them in the butt, in the butt. So if you need to work on getting yourself in a better position, quote unquote, better position or more fit position or from advantageous position from the court's perspective, then please do. Please spend the money, whatever that is. I don't know what it is. And find a program. There's not a lot of resources like they used to be pre-pandemic for a lot of things, but there's some new ones that popped up. So find programs, community organization, whatever. Sometimes relocating to a different county may be better, or different state, adjoining state might be better, or more advantageous for you because it affords you or it allows you to qualify for resources that you would never have qualified for had you stayed in your previous. So you see what I mean? That's all about strategy. To me, everything is strategic in family court. Everything I do, everything I speak about is always from a strategic point. So, and so you're toward the end of your case and you're about to go to trial. So again, expert witnesses or advisors or consultants, rehabilitation services for yourself, you know, money to relocate or get a better apartment or to fix my bed or whatever that is. Excuse me. Acquiring information, meaning doing doing investigation to find information or get a hold of documents or proof or evidence. Those are the other things that will usually generally come up. Sometimes the court will impose additional fees on guarding that item is one. Evaluations is an appraisal is an so things like that. When the court imposes things on you that require additional fees or additional costs, a lot of times there are no workaround. However, specifically as pro se, when an attorney is involved, which is like a catch-22, attorneys know how to, first of all, attorneys know what the workarounds are, and they know how to get the court to be inclined to grant the workaround. Because usually when the court gets involved when the court assigns or appoints or orders you to do these additional things, these additional service, there is no, negotiating. But a lot of times there are instances, there are caveats, or there are exceptions that the court might be open to listening to or adhering to if you know how to make them. And again, pro se litigants, I don't know pro se litigants being successful at that. I mean, there are times where the judge will order you to work with a guardian item. The guardian item hits you with this initial retainer that they want from you. It's $2,500. You don't have $2,500. You go back to court and you let the court know, or the guardian item lets the court know that night of you paid his initial retainer, and so therefore nothing has been done. And you just merely say to the judge, "I don't have the money." The judge can do a few things. The judge can drag your case on as long as it takes until one or both of you pay that money. The judge can dismiss your petition and your cross petition, or the judge can impose an order, a temporary order will stand, or even a final order that will stand until one or both of you decide to go back to court later on down the line, for whatever reason. So I guess that is a workaround in some respects, but it depends on where you are. It depends on who your judge is specifically, because some judges, for whatever reason, insist that, you come up with the money. And then some judges will understand that, yeah, you know what? I'm happening. This is just clogging up my calendar. Let me just get rid of this case, or let me move it off the calendar, or whatever they decide to do. And guardian item fees can run up into the tens and twenties of thousands. I don't think anybody's ever paid me that amount. I've, had colleagues who ran up cases. I think the most I've ever ran up the case was maybe $10,000. No, nothing beyond that. And so, drug testing. Sometimes drug testing. How about supervisory visit? When you have to pay the supervisor. And some of those supervising agencies want $150 an hour. Or the travel to get to the supervising agency, you don't have a car. And you need to take Uber. Or you need someone to give you car fare. I mean, all of these things should be considered, though, from the beginning. Try to consider and that's why I'm doing this show. That's why I'm doing this episode, to give you an idea of what to consider from the very beginning. There's nothing worse than for you to, start it or find yourself in the middle and you are, on the upswing, and then you're hitting all these walls because you don't have the resources. And so now that upswing is just basically swung to the other party's advantage. And now everything just fell apart. So the more you try to anticipate these costs and the workaround in the beginning, the more you increase your chances of actually succeeding at whatever it is you're trying to accomplish. And so the additional costs that may be associated with your case when you're in the thick of things, which I usually call as lane 3 cases. Lane 3 people, which is the ones who've been in court 6 months or more, and in the court again, and they look like no one. That you have to be careful, because that's when the costs usually really out of control. They get so crazy, so exorbitant, so enormous that so many people wind up basically selling their soul at that point, and only to be out of the money, still quote unquote losing their case. Again, because a lot of times, because the decisions they're making decisions, not thinking clearly, not making informed decisions, letting the emotions dictate the decisions they make, and it winds up biting them in the butt in the end. So at this stage, at this juncture, be careful about everything that you think you're supposed to spend money on. Attorneys, if you decide to get an attorney at this point, at this juncture, again, you're in the thick of things. You can't. It looks like it's gonna go to trials, and even be mindful about how you look for an attorney. Because if you're looking for an attorney and you're asking for referrals from people who worked with an attorney, you have to be mindful that the people you're asking for, they may have, different interests. So they may think that the attorney they had was superb, was A1. And, you get to meet with them and you get to work with them, and they're the worst. Why is that? Because your issues are different, your personalities are different, your ways of communication is different. Everything is different. Everything is different. So be mindful of that. Everything should be actually group one, especially when you're in the thick of it, because this is the time. This is it. And if you mess up now, and you've been embroiled this long, and you mess up now, you may have to wait. God knows how long to try to fix this or undo this. But worse, if it's your kids' safety, mental, physical, spiritual safety in jeopardy, you may not get another chance. You may not get another chance. The costs that come up during, this part of your case, please do it with much more scrutiny. If you're at this stage in your case and you want to work with somebody like me, we would absolutely need to work with each other for at least 1 month, so that we can get a halo of what's going on, and to help you start to think a certain way, and to start shift your mindset and your habits and your behaviors a certain way. At this point, your emotions may not be as high as when you first started, but it can be a cycle. You can go up and down and up and down and up and down at this point. And so there might still be times where you would make decisions or make moves out of, emotional reaction, instead of focusing in your common sense, if that's such a thing anymore. So you're at the trial stage. I always tell people that the trial stage is usually where you spend the most money. Why is that? Because you're putting everything into proving and preparing your case, preparing yourself. You're trying to make the most cohesive, the strongest, the most persuasive case you possibly can. And that takes work, effort, and money. I don't know anybody who's actually done a full-blown trial, whether it be divorce trial or custody trial. Well, yes. Well, I don't know if they've actually won. So I know people who's done it. And I know a couple of people that I work with who's done it and actually prevailed. They succeed. But I'm talking about a first time around custody trial or first time around divorce trial, and actually did it pro se, didn't spend any money, and still managed to quote unquote win. I don't know anybody who's. So I'm sure they exist, but I wouldn't. If you are pro se, you're going to trial, divorce or custody, you should really be working with someone who can help you not only choose what to spend money on or what not to spend money on, but to help you, prioritize things, organize things, and analyze things. Absolutely help get so. If it's after that, if it's post judgment, which means there's already been a trial, and now in that period after the trial, shortly after the trial or the hearing, and you're deciding what you want to do because the decision of the judge's ruling wasn't advantageous, it wasn't something you wanted or you like, then you need to think about appeal. And appeals are very, very expensive. Appeals can be extremely, incredibly not more expensive than spending, money on lawyering and guarding item fees and the valuation fees and all that, and expert fees. But if you're pro se, you manage to avoid all those fees during that part of your case, it's almost impossible to avoid it at the appeal stage, and you want to do an appeal. Just the transcripts alone that you need to get. You file your appeal, it can usually run you up to the $10,000-$20,000, and that's just for the trend. So that's usually what the biggest expense comes from, is getting the transcript. Maybe court filing fees as well, but that depends on where you are. Anyway, I hope this was really, really helpful. I hope that you take my advice and really plot out what resources you have, what resources you would need, and how you would allocate them, if you do have resources already. Those are really, really important. That is part of strategy. Having money or a little bit of it and deciding what you're going to spend it on while you're going through this part of your life on the court map is strategic. A huge part of being strategic. If you need help, again, feel free to reach out to me. If it's just 1 hour, do 1 hour. Or if you're in the thick of things and you need more than an hour, a month, 3 months, 6 months, and we will work on that. We will work on. I assure you, we will come up with a strategy that's going to work for you. The longer we work together, the better and more cohesive and stronger the strategy that we would come. So I'm here for that. I'm here for you. Thank you so much for listening. I want to thank you for joining us here at Self-Representing in Family Court, where we discuss all things strategy in family court. Join us next time. Until then, visit us at www.thedivorcesolutionist.com.